Good afternoon. Welcome to the Heritage Foundation and our Lewis Lehrman Auditorium. We, of course, take this opportunity to welcome all those who join us on our heritage.org website on all of these occasions. And as we do prepare to begin, we do appreciate everyone checking that your cell phones have been turned off as a courtesy to our speaker, as well as those recording today's events. We will post the program within a day or so on the Heritage homepage for your future reference. And of course, our internet viewers are always welcome to send questions or comments at any time, simply emailing us at speaker@heritage.org. Hosting our guest today is Sarah Tory, policy analyst in our Richard and Helen DeVos Center for Religion and Civil Society. She focuses on policy issues related to religious liberty, marriage, and family. She posts regularly about family and religion topics on the Foundry, Heritage's policy blog, and often uses the resource we have at familyfacts.org website for those blogs. Her work has been cited by the New York Times, among other media outlets. Her commentary has appeared in major newspapers and digital journals, such as National Review Online, and she appears regularly on radio programs across the country. Prior to joining us here at Heritage, we are always pleased to note that she worked her previous year as a think tank intern in education policy. She received her degree in political science from Villanova University. Please join me in welcoming Sarah Tory. Sarah?
Thanks, John, and thank you all for being here today with us and braving these very Arctic temperatures to be here. If you were in town yesterday, you would have noticed that there are actually many more people who are even braver than you, because there were hundreds of thousands of them standing outside for hours on end to participate in the March for Life. For over 40 years, Americans have flooded the National Mall every January to mark the anniversary and protest the Supreme Court's decision in Roe v. Wade and its accompanying case, Doe v. Bolton. It might seem remarkable that two decisions could face such sustained and even increasing opposition after so many years. After all, in 1973, supporters proclaimed that the court had settled the abortion issue once and for all. But more than 4 decades later, Roe v. Wade remains among the most unsettling decisions in law. That sweeping decision essentially invented a right to abortion and has been used to advocate for abortion on demand for any reason throughout all 9 months of pregnancy. Excluding the youngest and most vulnerable children from the right to life remains a stance at odds with the majority of Americans and has come at unspeakable cost. Since 1973, legalized abortion has ended the lives of more than 55 million children. Abortion on demand daily endangers women's health and safety and has sentenced countless women to physical and emotional harm. It not only victimizes both mother and child, but has harmed all of us by creating a culture that disregards the dignity of human life, demeans motherhood, and denigrates men's role as fathers. As we mark yet another year under the deadly ethic of Roe v. Wade, we have to reflect on how we got here. How did the Supreme Court justices develop such a controversial decision? Did they realize the profound consequences of their decision for law, politics, and women's health? And most importantly, how can we work to restore the protection for the right to life of everyone in law? We're delighted to have Clark Forsythe with us here today to discuss his extensive research on the development of the Roe decision and provide us answers on where we can go from here. Clark is senior counsel at Americans United for Life and author of the new book, Abuse of Discretion, the Inside Story of Roe v. Wade. His 27 years of service at AUL includes founding and directing the AUL project in law and bioethics and serving for 6 years as vice president and general counsel, overseeing AUL's nationwide litigation and legislation strategy. He has been co-counsel for parties in 3 U.S. Supreme Court cases and has argued cases before federal and state courts and has testified before Congress and state legislatures. He's also a prolific writer on pro-life law issues, having published more than 15 law review articles and book chapters. Clark holds a law degree from Valparaiso University and received a master's in bioethics from Trinity International University. Please join me in welcoming Clark.
Thank you, John, and thank you, Sarah, for that kind introduction, and thank you all for coming this afternoon, and those of you on the web, to hear about the little-known case of Roe versus Wade. Now, Sarah has done an excellent job of describing the controversy that Roe has engendered over the last 41 years. But the standard history of Roe, at least within the Supreme Court, is that Roe versus Wade was well-reasoned, that it was done with care. That's what Justice Powell said in 1983 in the Akron decision when he said it was, quote, considered with special care, unquote. And then in 1992, a decade later, the plurality opinion in Planned Parenthood versus Casey said that Roe was, quote, a reasoned statement elaborated with great care, unquote. That proposition is no longer tenable based on the record that we now have today. Because over the last 10 years especially, several of the papers of several of the justices have been released to the public at the Library of Congress, at Yale Law School, at Washington and Lee, and they tell a very different story about the history of Roe versus Wade than you've ever heard before, than I had ever heard before, despite having studied the decision for years, having studied it in law school, and having written about the decision for many years. And I think, frankly, that Abuse of Discretion is the most important book written about Roe since Roe because of these papers. And they are extremely important because there was simply no record in the case. There was no trial, no evidence, no record. And what appears on the face of the opinions is less than what went on behind the scenes and what's you can tell about in the opinions. I started on this journey back in 2008 or 2009 because I was curious about why the court had issued such a decision that was so unsettled, creating increasing controversy at that time, 38 or 39 years later. And I first started to look for the transcripts and the original audio of the decision. And at that time, you could find the audio and the transcript of Roe versus Wade on the website oyez.org, oyez.org, which is part of the public announcement by the clerk welcoming the public to public sessions of the Supreme Court. Oyez.org had the audio and transcript of Roe versus Wade, but I couldn't find the audio and transcript of Doe versus Bolton. And in anthologies over the last 40 years, they typically ignore Doe versus Bolton, despite its considerable impact on abortion policy in the United States. So I was curious at the time, why such a sweeping decision? What did the court know? What did the justices know? What was in the record? I assume there was a record. And what could I tell from the Doe versus Bolton audio and transcript that wasn't available in the Roe versus Wade audio and transcript? Well, the usual critique of Roe versus Wade is that the abortion right it created is nowhere found in the text, structure, or history of the Constitution. And while that's all true, abuse of discretion takes somewhat more of an updated and pragmatic perspective because the court assumed the role of the National Abortion Control Board. They didn't just strike down laws, they wrote an entire national abortion law of quite considerable detail, and they have imposed it directly or through the federal courts ever since. That's basically what Justice O'Connor acknowledged in her Akron dissent in 1983, calling it the Supreme Court the ex officio National Medical Board, with powers, she said, to approve or disapprove standards and operative practices all over the country. So part of the question that I attempt to answer in abuse of discretion is, what was the court's record, and how has that transpired? What do we know about the court's handiwork as the National Abortion Control Board? And has it been good for women's lives, which is today the court's rationale for sticking with Roe? Well, before I go any further, I think it's important for any audience that I start by just making clear what we're talking about. What we know as Roe versus Wade, what the public calls Roe versus Wade, is really two cases. It's Roe versus Wade and Doe versus Bolton. And you can't understand our national policy on abortion unless you read both of those cases. In fact, the court in Roe instructs us that we have to read both of the cases and that they're to be read together. Well, in Roe, the court suggested that the states could prohibit abortion after fetal viability, quote, except, they said, where it is necessary and appropriate medical judgment for the preservation of the life or health of the mother, unquote. But then in Doe, the companion case, the court added a significant health exception that is typically overlooked. The justices defined health as, quote, all factors, physical, emotional, psychological, familial, and the woman's age, relevant to the well-being of the patient, unquote. So health, uniquely in abortion law, means emotional well-being without limits. And the health exception in Doe swallowed the supposed ability of the states to prohibit abortion after fetal viability, as it's commonly been characterized in the public. So Roe and Doe were sweeping decisions. It isolated the U.S. as one of only 4 nations that allows abortion for any reason after fetal viability. And those 4 are the U.S., Canada, North Korea, and China. Well, here's how Roe happened. Roe actually began, and this was the first shock in looking at the justices' papers. Roe actually began as a procedural mistake. The court took the 2 cases in April of 1971 not to decide the abortion issue, not to address abortion, not to declare a right to abortion. They took the cases to decide a mundane procedural issue about the jurisdiction between state and federal courts. Lawyers might recognize it as the case of Younger versus Harris. Younger versus Harris dealt with whether state court defendants of any kind of factual scenario could take their case into federal court to get the state court prosecution enjoined. And there was a lot of indication in the papers that that was the central reason the court took the cases, to apply Younger versus Harris, decided just 60 days before, to the factual scenario in Roe versus Wade and Doe versus Bolton. But then a crisis erupted in the courts. After the court took the case with Justices Black and Harlan on the court in April 1971, in September 71, a crisis erupted when Justices Black and Harlan abruptly retired within the space of a week due to ill health. Justice Black died a week later, and there was a national funeral for him. Justice Harlan died at the end of 1971. That reduced the number of justices to 7. It flipped the balance of the court, and it empowered a temporary majority of 4 justices, Justices Brennan, Douglas, Stewart, and Marshall, to then use the cases taken to decide this procedural issue, to use them to declare a right to abortion and to sweep away the abortion laws. And there was a certain, there was a great deal of political overlay over this, because those 4 wanted to decide the cases and get them decided and settled before President Nixon could fill those 2 vacancies with what eventuated in Justice Powell and Justice Rehnquist in January 1972. But the 4 want to decide these cases, as they did other cases during that vacancy, by a 4-3 margin and get them decided. Another important case that was decided during that 15-week vacancy is Eisenstaedt versus Baird. And there was another case, a jurisdictional case called Meacham versus Foster, which was also decided during that 15-week vacancy, that addressed the exact jurisdictional question that that Roe and Doe were originally taken to decide. So there was a considerable power play during the 15-week vacancy. Well, the case is first heard in December 1971. Chief Justice Berger assigns the case to Justice Blackmun for reasons that Blackmun says he never quite understood. The 4 reacted to this and wanted to challenge Berger's assignment of the opinion to Blackmun, because Berger's vote was a little unclear during the conference in December 71. They challenged Berger, but Blackmun stayed with the assignment of the opinion, and he takes 4 or 5 months to write a first draft of the opinion, and then releases it in May of 1972. But it was a very narrow opinion, a very narrow draft, limited only to striking down the Texas and Georgia laws because they were unconstitutionally vague. Didn't really create a right to abortion, didn't strike down the laws across the country. The four then reacted to that opinion, and they again tried a power play in which Justice Douglas threatened to release a scorching dissent if the justices decided to re-argue the cases in the fall. And although Douglas did not release that scorching dissent, it ended up on the front page of the Washington Post and the New York Times over the 4th of July weekend of 1972. Who released that? Well, apparently it was Justice Stewart released it to the press because he couldn't stand Chief Justice Berger and wanted to embarrass Berger. Well, despite the power play, Powell and Rehnquist agreed to vote to rehear the cases, and they were heard a second time in October of 1972. Justice Blackmun still holds the appointment of the writing. He drafts a second and third opinions, and they're finally released in January 1973. But throughout that time, there were numerous mistakes the justices made, the four especially, because they pushed to take these two cases that were taken on jurisdictional grounds. And the first mistake is that there was no record of facts. The two cases that were taken in April of '71 to decide the jurisdictional issue didn't need a record of facts on abortion and its implications. And when you realize that Justice Black and Harlan agreed with that, they were scrupulous judges who were attentive to the records, that they didn't need a record on abortion or its implications to decide the jurisdictional issue. But when the four decided to then use the cases to decide a right to abortion, to sweep away the abortion laws, they had two cases with no facts, no record, no trial whatsoever about abortion or its implications. In that factual vacuum, they were susceptible to untested, unprecedented theories of medicine and law and history. And one of the medical premises or assumptions that they latched upon was the medical myth that abortion was safer than childbirth. And that drove the outcome. It drove and it shaped their notion of historical right to abortion, the fact that they deferred to providers and gave great deference in Roe and Doe to providers. It drove their prohibition of health and safety regulations in the first trimester. It drove their expansion of the right to viability and beyond. And yet, there was no trial, no record substantiating this. It was just argued in interest group briefs in the Supreme Court, primarily by Planned Parenthood Federation of America. And there was no existing obstetrical textbook in 1971-72 that made such a claim that abortion was safer than childbirth. The justices cite, Justice Black and Justice Douglas in his concurrence, cite 7 medical sources between the two of them. But if you look at those sources, as I do in abuse of discretion, there's no reliable data there. The sources don't provide any data that would allow you to conclude that abortion is safer than childbirth. The third mistake is that over the course of the first oral arguments and the second oral arguments and the writing of the first 2 or 3 drafts of Blackmun's opinion, he assumed that he was creating a right to abortion up to 12 weeks. And even in the second round of arguments in October of '72, he assumed that he was drafting a right to abortion up to 12 weeks. And it was in his third draft opinion in November of '72. In 4 hours of oral argument, there was no mention of viability whatsoever. And you can confirm that yourself if you go to the website oea.org and read the transcripts and hear the audio. Viability was never mentioned once. The word was not mentioned once. Only after the second round of oral arguments, and he released a second or third draft, then the justices start negotiating behind the scenes as to the scope of this right they're creating. And Justice Powell in particular and Justice Marshall prevailed on Justice Blackmun to expand the right from what they thought was the first trimester, 12 weeks, to what they thought was viability at that time, about 28 weeks. So they were expanding access 4 whole months, 16 whole weeks, despite the fact that they had no medical data whatsoever about the implications for late-term abortions, live birth abortions, implications for women's health from late-term abortions. No evidence whatsoever. And they expanded it 16 weeks, 4 months to 28 weeks, simply for the pragmatic reason of opening up access. And then, of course, they created the health exception, which allowed abortion for any reason related to emotional well-being, even after viability. The fourth mistake is that based upon the medical myth, they prohibited health and safety regulations in the first trimester when today 90% are done. And the court has yet, in 41 years, has yet to approve clinic regulations. They have not addressed a case that has approved clinic regulations in the first trimester. Those that exist are kind of in limbo and subject to the discretion of the federal courts. Well, there are some additional benefits of the book in the second half. The first half focuses upon the mistakes the justices made. The second half focuses upon some of the unintended consequences flowing from this sweeping decision. One is that the justices had only a vague inkling about state protection in 1971-72 for the unborn child in property law, prenatal injury law, wrongful death law, fetal homicide law. There was some protection in the law in those areas, and that was introduced in the briefs in the Supreme Court. But Roe versus Wade and Doe versus Bolton is exclusively focused on abortion. It says nothing about what the states can do in these other areas. And yet the states, based upon the status of the law in 71-72, the states have moved ahead with protection in all of these areas. There are now fetal homicide laws in 36 to 38 states. 25 states, half of the states in this country, have a fetal homicide law that begins protection from conception. There are wrongful death statutes in 36 to 38 states that protect the unborn child. And virtually every state has a prenatal injury law that protects the unborn child from conception. So this has introduced what some have called schizophrenia, that the court really had no awareness of and no inkling. The second part of the book also addresses the growing body of international medical data, international medical studies on long-term risks to women from abortion. Some of the studies existed in 71, 72, suggesting long-term risk of cervical incompetency and preterm birth. But there wasn't a wealth of data that we have today. Today there are more than 130 international peer-reviewed medical studies finding an increased risk of preterm birth after abortion, covering women or addressing women from more than 30 countries. We now have more than 100 international peer-reviewed medical studies finding increased risk of mental trauma after abortion. And we have more than 70 international peer-reviewed medical studies finding increased risk of breast cancer after abortion. Now, this finding increased risk is not the same as causation, and there are some medical studies that find no increased risk. But yet, there is this growing body of data that the court had no information about, and certainly they had not before them in 1971-72. Well, these mistakes and the history in abuse of discretion is not just history, because the mistakes made by the justices in 71-72 have been before the court and could be before the court in future cases. The supposition that abortion is safer than childbirth is challenged by the 20-week limits that have been passed by 13 or 14 states since 2010. The viability rule, and whether the viability rule in fact endangers women's health with the risks of late-term abortions, that too is challenged by the 20-week limits. And the court had a case from Arizona involving Arizona's 20-week limit that was before the court this winter, and unfortunately the court about 10 days ago denied review in that case called Horn versus Isaacson from Arizona. But there are 12, 13 or more states with 20-week limits, and it's possible that another 20-week limit case could get up to the Supreme Court. So where are we in 2014? You're familiar, I'm sure, with Planned Parenthood versus Casey, the 1992 case, which on one hand reaffirmed Roe versus Wade based on the reliance interests of women in abortion as a backup to failed contraception, as the court said. But the Gonzalez Gonzalez versus Carhart in 2007 is really the more important case. That upheld, in its strict legal holding, upheld the constitutionality of the Federal Partial Birth Abortion Ban Act. But there is also considerable language in the Gonzalez majority opinion written by Justice Kennedy about concern for late-term abortions and their impact on children and on women's health, considerable concern about the violence of late-term abortions, and giving more the decision in Gonzalez gave more deference to the states to pass regulations and perhaps some partial prohibitions. And the 20-week limits that were passed since 2010 in 13, 14 states were passed in response to the Gonzalez decision's seeming invitation to enact a broader limits on late-term abortions. And the Arizona statute was justified by medical data showing medical evidence of fetal pain at 20 weeks, as well as considerable medical evidence showing the greatly increased rate of maternal mortality to women in the second trimester. So the Arizona statute focused both on fetal pain as well as maternal health, and unfortunately the court decided not to take that case. And so today there is no abortion case at the Supreme Court, although there are cases in federal district courts and federal appellate courts on an array of issues that could get up to the Supreme Court in the next year or two. But in these future cases, especially the 20-week cases, they could challenge the notion that abortion is safer than childbirth. They could challenge the viability rule. And they could bring before the justices the body of international medical data that I've described. In addition, in Gonzalez, traditionally the court in Roe versus Wade said that there are only two state interests the states can use to justify regulations, and that is an interest in fetal life or an interest in maternal health. But in Gonzalez, Justice Kennedy, writing the majority opinion, suggests that the states shouldn't be limited to these interests. There may be additional interests, standards for the medical profession, perhaps protecting the standard of medicine and the standards for the medical profession, and perhaps other state interests that the states could bring forth to justify state regulations or prohibitions. And the court could address these in future cases, but the anomaly we see ourselves in is that the court has denied 3 abortion cases that were appealed to it in the last 3 months, has no abortion case before it, and the court could just continue to deny cases and not hear them. But if it has assumed the self-appointed role as the National Abortion Control Board, then it acts only through litigation. And if it doesn't hear cases, how can the court and the justices ever be brought up to date as to what is happening in clinics and what is happening with medical standards in clinics across the country? And one of the questions I leave abuse of discretion with at the end is, given the court's track record, what justifies the court continuing as the National Abortion Control Board? I mean, why should abortion, among all the public health issues, be controlled so intensely and decided by the justices? 41 years later, those questions still need to be asked and answered. And thank you for being here today, and I'd be happy to answer any questions.
Thanks very much, Clark. That was excellent. We'll have some time for questions. We have a couple of mics that we can pass around. I ask you that you wait for that. Give us your name and affiliation just for the folks who are watching online. I might start. Clark, there's often a misunderstanding that the day after Roe, that if there was ever a reversal or an overturn of Roe v. Wade or Doe v. Bolton, that abortion would be completely illegal across the land the next day. Can you address that and explain how that's a little bit of a misunderstanding?
Sure. Well, I published an article, op-ed yesterday in the Washington Times called "The Growing Cracks in Roe versus Wade," and one of the issues I did address is this public assumption that overturning Roe means the court makes abortion illegal. It's also assumed that overturning Roe means some federal prohibition comes back in effect across all 50 states, or that if the court overturns Roe, 50 state prohibitions come back into effect immediately. None of that is true. If Roe versus Wade was overturned today, abortion would be legal in 40 to 45 states tomorrow, perhaps all 50, up to 20 weeks or up to viability, because very simply, no abortion prohibitions exist on the books in those states, or there are state court kind of versions of Roe finding a right to abortion in the state constitution that would prevent any enforcement of prohibitions up to 20 weeks or viability. So the fact of the matter is if Roe was overturned today, abortion would be legal up to 20 weeks or up to viability in 40 to 45 states and probably all 50. If you go back and read Planned Parenthood versus Casey, even the justices themselves in Planned Parenthood versus Casey somehow assume that if they overturned Roe in Casey, it would mean abortion would be immediately illegal across the country the day after. And that wasn't true then, and it's certainly not true today. Other questions?
Thank you. Thanks for your talk, Glock, and especially for your book. Richard Dorflinger of U.S. Conference of Catholic Bishops. I wonder if you could say something about the fact that the court didn't just legalize abortion after viability; it sort of created it. One of the books on my shelf is a terminology textbook from the American College of Obstetricians and Gynecologists from 1972. Definition of an induced abortion is the induced termination of pregnancy up to 20 weeks. Medically, the whole idea of a post-viability abortion was, how did they even come up with the idea that there could be such a thing?
Well, there was no record, no evidence, so they were not tied to any factual record, and the move to expand to viability after the second argument in November of 70 and December of 72, just 4 weeks before the release of the opinions, was completely tied to the pragmatic judgment that if we're going to create a right to abortion, we might as well create a broad one so there's access. As you indicated, abortion was defined as before 20 weeks by medical texts of the time, and anything after 20 weeks was actually called a premature delivery, not an abortion. And no medical group filing an amicus brief before the Supreme Court in Roe or Doe argued for viability. No amicus brief filed in the case argued for viability as a marker. The parties didn't argue for viability. And interestingly, if you go hear the audio or read the transcript, viability was not mentioned once, and the only marker, the only time-based marker that was brought before the justices and involved in one or two questions was 20 weeks, because a model law at the time had limited abortion to 20 weeks. And there was one or two questions between a justice and I think the attorneys for the Georgia plaintiffs about whether it would be constitutional to limit abortion to 20 weeks. And her answer was something like, well, I assume there could be a limit of that kind. But that 20 weeks was the only gestational marker that was really involved in the back and forth and questions and answers. It's kind of stunning.
Keith Fierro, I'm an intern here. I was just wondering, up until the point, if ever the court reaches where they effectively overturn these cases, I was wondering if you foresee any sort of regulations that the court may potentially be open to in the coming years that they don't automatically label as an undue burden on behalf of the mother.
Well, the court has retreated from the harsh scrutiny of Roe versus Wade itself in 4 or 5 cases. Webster in '89, Casey in '92, Gonzalez in 2007. And in each of those cases, by retreating, the court has allowed greater space for the states to regulate. And the states have moved ahead with regulations. Every time the court has retreated, the states have moved ahead. And of course, there are a few federal laws. But the states have already passed numerous parental and consent laws, limits on abortion funding, informed consent laws, ultrasound laws as part of informed consent. Now the states have moved ahead with partial prohibitions. And the court has basically said that none of those cause an undue burden. And the technical question before the court in the Arizona 20-week case is whether a 20-week limit would be an undue burden, or as Justice Kennedy in Gonzalez seemed to focus on, he used the word substantial obstacle rather than undue burden. Is a 20-week limit a substantial obstacle to a safe abortion, which I think is really the court's standard of review today? If maternal mortality is greatly increased in the second trimester and goes through the roof after 20 weeks, then is it really a substantial obstacle if women actually have clear notice that there is a specific time limit and that they should make a decision before abortion mortality gets extreme? That would be a benefit to women and protecting maternal health. But if the court, perhaps the second part of your question is if the court truly reconsidered Roe versus Wade, determined that there was no federal constitutional right to abortion and returned the issue to the states, presumably the court would simply use a rational basis standard and determine whether the states had a rational basis to protect fetal life by prohibiting abortion. And that has been urged on the court in the Webster case in '89 and in Casey in 1992. And so there would, based on a rational basis standard of review, the states would have broad leeway to protect the life of the unborn child, protect maternal health by prohibiting abortion, by enacting broad prohibitions. I hope that answers your question.
Thank you for a great talk, Clark. I'm Chuck Donovan, Charlotte Lozier Institute. Your book focuses on Blackmun as the opinion writer, but I think you have some interesting things to say about Justice Brennan as well. How would you characterize some of the other justices who are working behind the scenes, particularly Brennan?
Well, the papers make clear that Justice Blackmun was a follower and not a leader. I mean, he's the named author of the opinion, but there's some interesting evidence in Brennan's papers that Brennan had a huge behind-the-scene influence that is kind of murky, and it's been suggested by many that Brennan held back, didn't want to pressure Blackmun too much, also didn't want to show his hand, didn't want his fingerprints on the opinion too much. But at the end of every term, Justice Brennan's clerks would bring together his written opinions in one bound volume. And for the 72 term that ended in June of '73, they put Roe and Doe in the bound volumes of the Brennan opinions, and with the ambiguous phrase, something that his influence was so great they felt it was justified in including Roe and Doe. Now, I didn't find specific evidence that he wrote the opinions or finished the opinions, but that has been suggested by others. But Justice Douglas clearly had a huge influence, and some historians have referred to Justice Douglas and Justice Brennan as the two leaders of the pro-abortion bloc at the court's conferences on the two cases. As I point out in Abuse of Discretion, Justice Douglas put a great deal of pressure on Blackmun at a number of different points. And Justice Brennan apparently didn't want to be that overt. But Justice Stewart lobbied him from time to time, Justice Marshall as well, and in the end, Justice Powell and Justice Marshall lobbied Justice Blackmun in November and December of '72 to expand the right from 12 weeks to viability. And in Powell's papers, there's an exchange with him and his clerks that he thanks his clerk for educating Powell about viability, because Powell thought he was the first person to raise the viability suggestion and urge that the right be expanded to viability, which at the time he was very proud about. But as Powell's biographer makes clear, Justice Powell eventually told his biographer that Roe and Doe were the worst opinions he'd ever joined. So he had regrets, at least about the opinions, if not about the right to abortion, after he'd retired. As to the others, Justice Rehnquist was, of course, a rookie justice in 72, and does not have a very strong dissent. In fact, he starts his dissent rather weakly by congratulating Justice Blackmun on his scholarship, which of course since then has been repudiated and refuted in so many ways. Justice White's dissent is rather weak as well, doesn't get into a great deal of analysis of many of the points. And one of the questions that I got done with abuse of discretion and couldn't answer is, why did these justices never raise any question, even the dissenters, White and Rehnquist, the only two dissenters, why did not they raise the absence of a record? I mean, if you go back to 1927, Justice Brandeis, for a unanimous Supreme Court in a case called City of Hammond versus Shappey Bus Lines, for a unanimous Supreme Court, Brandeis writes, "We will not decide these constitutional questions without an adequate record found with facts determined by the lower courts." And the court has, before Roe v. Wade and since Roe v. Wade, even opinions by Justice Blackmun himself, had said, we will not decide constitutional cases. We will not decide constitutional claims without an adequate, full-bodied record. But that's not, that objection is not to be found in the dissents, and it's a mystery as to why not.
Bill Saunders from AUL. I just want to follow up on something Chuck's question suggested, and also Sarah in her introduction, she said, did the justices understand the profound consequences of their decision in Roe? And I wanted to ask you, in light of the letter from Justice Douglas, that doesn't seem to understand the consequences of Roe. I don't remember the exact words of it. You might comment on that, because Douglas is once one of the movers for Roe, and yet he writes a letter shortly thereafter in which he doesn't seem to understand Roe.
Yes, Bill's referring to a letter by Douglas to Chief Justice Berger in March of '73, about 7 weeks after Roe and Doe were released on January 22nd, 1973. And Douglas writes to Chief Justice Berger to tell why he's voting to deny review, deny cert in an abortion case from Indiana called Cheney versus Indiana. And he says he does so because our decisions in Roe and Doe were limited to two conditions. First, he says that the abortion, if it's going to be performed, be limited to the first trimester. And secondly, that it be backed up by a appropriately guarded medical judgment, he says. And that's the second indication that Douglas didn't realize the sweep of the opinions, because if you read his concurring opinion in Doe versus Bolton, he basically says that the right's limited to quickening, which is traditionally considered to be about 14 to 16 weeks. Quickening was talked about in the briefs and in the oral arguments, but quickening is 10 to 12 weeks before viability. And yet in his concurring opinion, he has this obscure statement that he believed that the right was limited to quickening, that they had just pronounced. So it's unclear as to why he was so confused. Other questions? Yes.
Thank you, sir. My name is Wiley Drake, Congressional Prayer Conference in Washington, D.C. In your opinion, legally speaking, what kind of case would it take to come and pass the Supreme Court in order to outlaw abortion in America?
Well, let me kind of take that in two parts. First, there's this legal myth out there that no case can challenge Roe unless it involves a perfectly drafted law that perfectly prohibits abortion and that sets up a perfect record. That's completely untrue. The fact of the matter is that the justices could reconsider Roe versus Wade in any case involving any law or regulation that arguably conflicts with Roe versus Wade. A parental notice and consent case that arguably conflicts, informed consent, or any other kind of regulation. Because as Justice Kennedy and Scalia have made clear in previous opinions, in any case involving a law that arguably conflicts with Roe, the justices have to decide what standard are they going to apply. Are they going to apply the Constitution? Are they going to apply Roe? Or are they going to apply some other standard? So Roe is always lurking in the background. The second part of your question, though, is that the justices in Roe versus Wade and Doe versus Bolton read briefs in the Supreme Court, heard oral arguments arguing constitutional personhood. That was argued by the Assistant Attorney Generals in Texas. It was argued by Dorothy Beasley, the Assistant Attorney General for Georgia, in the two arguments in Doe versus Bolton. They got full arguments about constitutional personhood, but as you know, they denied that the unborn child was a constitutional person. Now, the unborn child is in fact a person in the laws of most states, either in property law, prenatal injury law, wrongful death law, or fetal homicide law. It is a statutory person. It was a common law person. But the court has denied that it is a person within the 14th Amendment of the Constitution. And even today, of course, Justices Scalia and Thomas are on record as saying that they do not believe that the unborn child is a constitutional person, on the basis that the abortion issue was always a state issue. It was a colonial legal issue. Then it was a state issue. There is no precedent declaring, before Roe or Doe, no precedent declaring the unborn child to be a constitutional person. The word unborn child and abortion is not in the Constitution. It's not in the 14th Amendment. And I suppose, finally, they have identified institutional reasons that are somewhat obscure and are often overlooked. And that is, the assumption is that if the court declared the unborn child to be a 14th Amendment person, it would be taking the country from abortion on demand to a national prohibition on abortion in one fell swoop. And Justices Scalia and Thomas have said the court should be out of the abortion umpiring business. It should not be umpiring abortion either way. It should not be deciding whether abortion laws are too restrictive, and it should not be deciding whether abortion laws are too tight or too loose. And so for that institutional reason, they have basically said the court should be out of the abortion umpiring business. But if the court declared the unborn child a constitutional person, it would be fully involved in abortion umpiring still. And so it seems most likely, based upon who's on the court today and what Justice Scalia and Thomas have said, that if the court overturned Roe, it would overturn the national right and return the issue to the states and allow the states to draft new laws and perhaps prohibitions. That seems to be the most likely scenario if the court overturned Roe. I hope that answers your question.
Thank you.
Yes.
Thank you. My name is Alan Parker, and I currently represent Sandra Cano, who was the Doe of Doe v. Bolton that you've referred to. And she's obviously very strongly pro-life now, and as your research indicated, she never even really wanted an abortion. She felt there was a great fraud on the court in the Doe and Roe cases, but particularly on the Doe case, in that the documents were fraudulent, which also didn't really come out because there was no trial and no record in her case. But in I want to really just go a little bit more hopeful in the Gonzalez v. Carhart case, which you've mentioned as saying the most recent Supreme Court decision. They actually cited Sandra Kano's brief and 180 women hurt by abortion to say that women come to regret aborting the infant life they once created and sustained, and that severe depression and loss of esteem can follow. So do you see that this evidence of the damage that abortion in fact causes to women can have an influence on the court?
Absolutely. And the Arizona case, Horn versus Isaacson, which the court denied cert on 10 days ago, also provided additional medical data and evidence about the negative impact of late-term abortions on maternal health. So given the invitation in Gonzalez and the interest in Gonzalez with the medical data about the negative implications on maternal health, you would have thought that the court would have been interested in the Arizona case and the record in the Arizona case. So it was a disappointment that the court didn't take the Arizona case when there was a good record on that. But if I may touch on the first part of your statement and question, Alan, Sandra Kano, or Mary Doe in the Doe versus Bolton case, she had attorneys originally filed suit on behalf of her, but as a number of historians have pointed out, but although it's little known, when the case was ongoing in Georgia and she felt her baby kick, in traditional legal terms, it quickened, she called up her attorney and said, I don't want an abortion, I want out of this. And yet, because there was no trial and no record in Doe versus Bolton, her attorney was eventually able to go before the Supreme Court and tell the justices, as you can read in the transcript and hear in the audio, that Mary Doe didn't get an abortion because of poverty. They never heard that she wanted out, never heard that she relinquished her desire to have an abortion once she heard her baby kick, because there was no trial or factual hearing in Doe versus Bolton, and the justices never heard that. Other questions?
Thank you. I'm Sharon Turner, and I want to give this as my association and group that I'm here with today. I'm part of the first group of women in America who faced Roe. I was expecting our son in '73. And I need your book to re-enhance what you've shared and learn more. But this concept I have in my mind is you've outlined there's potential because of these 20-week limit states, that potential cases can come forth out of the states and challenges in those cases. And one could be in this viability. Well, I say these words now, what I want to ask. Yesterday, I had the beauty and the privilege of meeting and standing before two girls whose twin was aborted. No one knowing they were there, eventually people were not aborted. And I was able to say this to them, that I see in these challenges on the 20 weeks limit. I told them, I said, do you realize that the moment you were made and in your DNA is the power of the inalienable rights to be protected by the Constitution? It is your DNA that formed your mouth for your freedom of speech. It is your DNA that formed your feet for us to stand here right now and have freedom to assemble together. What about, and any suggestion you have, especially for every learning ear in this moment that has the legal capacity to go forth and input for this challenge, what about the power of the truth and evidence of DNA?
Well, thank you for your question. Your question and your statement, thank you very much, they bring up a lot of issues with respect to the court's management of this whole issue over the last 41 years. Again, the court has the self-appointed role as the Abortion Control Board, and part of your question addresses the fact that the court has prohibited the states from enacting health and safety regulations in the first trimester when 90% are done. You described lack of informed consent, the problem of potential coerced abortions. And yet the court has prohibited these regulations in the first trimester. And as a result, we have a public health vacuum that recently was publicized with the Kermit Gosnell scandal in Philadelphia, but that's just one of many incidents over many states over many years that keep arising. The court, the reason why the justices hold to Roe, according to what they have written, is not because of fetal development or the facts of fetal development, but because they think abortion is good for women. The court has addressed abortion in 29 or 30 cases, and in virtually all of those, it's had briefs on DNA and fetal development, and the court got full information and a full understanding about the impact of abortion on the unborn child in Stenberg versus Carhart, the 2000 decision involving partial birth abortion, where they got graphic medical testimony about what partial birth abortion does to ripping apart the unborn child. And they had the same testimony, if not more thorough and powerful, in 2007 in Gonzalez versus Carhart about partial birth abortion all over again. But in Casey, the court shifted the rationale for sticking to Roe versus Wade from history and legal history to sociology and what the court in Casey called the reliance interests in women in abortion as a backup to failed contraception, which basically means we like what we've done, women need abortion, abortion's good for women, and that is the rationale. That is the glue that holds together the justices behind Roe versus Wade. And so it's important to have a mother-child strategy, such as many pro-lifers have followed. We've pursued at Americans United for Life. It's important to emphasize both the negative impact on the unborn child and the negative impact of abortion on women. Both have to go together. It's not it's not woman versus fetus. Abortion's bad for both. And that kind of evidence needs to be brought before the Supreme Court in future cases. I hope that answers your question. Thank you. Thank you very much.
Thank you very much, Clark, for your insight and for all of your research you've done on this. I encourage you to check out getting a book outside. Clark will be here to sign it if you'd like. And thank you once again for joining us.